Good morning and welcome to the 10 a.m. session for oral argument with the 5th District Court of Appeal. My name is Rand Wallace. I'll be presiding over this case. I have joining me on the panel Judge Dan Traver and Judge Mary Alice Nardella. We have one case on the docket here at 10 o'clock. It's Precon Corporation versus Arch Insurance Company et al. And I'm going to assume the appellant would like 5 minutes in rebuttal. Unless you tell me otherwise, I would ask that the parties make sure that you keep any devices that may make noise on mute so it doesn't distract from the arguments. And Mr. Lewis, I will give you the floor. You may proceed.
Thank you, Your Honor. Counsel, may it please the court. And we'll see how well I timed this, but I'd actually like around 9 minutes reserved for rebuttal, please. My name is Chris Lewis, and I represent the appellant Precon Corporation. We're asking that this court follow its own precedent and reverse the summary and final judgments entered in favor of Arch Insurance Company, and on remand require summary judgment be entered in favor of Precon. Alternatively, we're asking that at least the judgments entered in favor of Arch be reversed. This case concerns the non-payment of a subcontractor, my client Precon, for work it performed on a public construction project. Like almost all public construction projects, a payment bond was issued pursuant to Section 255.05 Florida statutes. The surety in this case was Arch. That statute was specifically designed to protect subcontractors who don't get paid for their work on public jobs like this. The specific issue in this appeal is the statute of limitations. The statute provides a relevant part, and I'll quote the part here, that an action must be instituted within 1 year after the performance of the labor or completion of delivery of the materials or supplies. So the question is simply whether Precon performed labor or delivered materials or supplies within 1 year of filing suit. The parties below filed competing motions for summary judgment on that issue. Precon's motion was denied and Arch's was granted, the court finding that Precon's claim was barred by the statute of limitations. Really, this case is simple. It's a subcontractor who didn't get paid for its work, so it sued on the payment bond. And for its part, the surety looked for a reason to not pay or to avoid liability. It came up with the statute of limitations, and then it convinced the circuit court that the time to file should run from one particular and mistaken pay application, even where there was contrary evidence showing later dates that Precon performed substantive labor on the project. That was wrong and it constituted reversible error. Arch also asked the court to rely on precedent from relating to an inapplicable statute instead of relying on the controlling law from this district, and that was wrong too. That controlling
Let me ask you a question. You cited a case from 1964, second DCA case called Winchester, which basically says we keep the statutes separate because they relate to completely separate things. My question for you is, back in 1964, there was no 5th DCA. The city of Cocoa, where this project sat, was in the 2nd DCA. What precedential effect does that 2nd DCA decision, when the 5th DCA didn't exist, have on us? Are we bound by it?
I think, and I'm tempted to say yes, because I think that'd be helpful. But even if not, I think that it's still persuasive authority, being from another district, and since it covers the issue. But we do have, regarding this specific issue, we have a case from this district. It's the Federal Insurance Company v. XL of Orlando case, which of course I also cited. It's the only case in this district ever that performs a statute of limitations analysis on a 255.05 payment bond claim. It also happened to include an instance where the claimant had submitted a pay application that stated it was 100% complete with its work. The circuit court here was required to do what this court instructed it to do in that case, and that is evaluate whether the work performed by Precon within 1 year of filing suit was either substantial or trivial, including the work performed after this pay app. Here it is undisputed that Precon's work took several months to complete this particular work, several months to complete. And it required over 1,500 man hours at a direct field cost of over $60,000. All of that was after this mistaken payout. In the Excel case, the work was found to be trivial, but it expressly consisted of, quote, small items from a final list. This court found that the small items were trivial because, of course, they were small items. Our position is that Precon's work was indisputably substantial because no reasonable jury could find that several months of work and 1,500 labor hours was trivial. Therefore,
Mr. Lewis, is your position then that but for your client's erroneous submittal of the pay application September of 2015, that the evidence of the work continuing into July of 2016 made it such that there was no issue of genuine material fact?
yes.
Okay, so but for that error, you should have been granted summary judgment. Is that correct? Is that your position?
Yes, and even despite the error, because once Precon realized its mistake, it immediately undertook to go out there and finish its work. And it was a substantial amount of work. The circuit court also seems to have misunderstood the evidence as it concerns the pay application. Precon filed suit on April 6, 2017. The circuit court relied on this mistaken pay app, but it called it Precon's final bill. Precon's final bill was submitted later on November 9th, 2016, which was well within a year of the time Precon filed suit. So if it was appropriate to rely on Precon's final bill, Precon's complaint is timely under its final bill. The mistaken pay app was only signed to the best of Precon's knowledge, and everyone disagreed that Precon's work was done. The owner, the engineer of record, and then, like I just said, Precon itself once it realized. But I think most importantly, using a pay application ignores appellate court precedent and the legislature, who wants us to determine when the labor was performed. It doesn't want us to find a pay app. It wants us to determine when labor was performed. So neither in this context or the Chapter 713 context, the ARCH asks us to use, in neither is a pay app ever a dispositive factor. There are some cases where a pay app is cited as further supporting evidence of the real material determination of what work was performed and when. And I think ARCH even states that in its answer brief. A pay app can only be useful if there's no other competent evidence as to the date of the work. Here, there's an abundance of other evidence. There's the substantial work performed by Precon after the pay app. There's months of daily logs and other record evidence showing Precon's work, Precon working almost continuously during this time. There's 2 sworn affidavits of Precon, sworn interrogatories, the final bill sent in November 2016, and then the engineer of records testimony, which I'd like to highlight. He was the only construction professional and only witness in this case other than Precon. And his testimony was that the work wasn't done, that pay apps are not reliable evidence for determining when work was done. He said that there were items in a December 2015 letter of his that Precon had not started yet, still needed to do. And though it's not dispositive, he certified that Precon's work was substantially complete in August 2016. And I submit that that's much more probative than a pay app that everyone agrees was wrong. And it's not just the law, but the equities are also in favor of Precon here. Precon just made a mistake in its pay app, and then it went out and it did the right thing. It's not trying to get away with anything. And there's also no evidence in the record that Precon continued to ask for payment once it realized its mistake. It didn't ask for payment again until it submitted its final bill much later. The taxpayers in the city of Cocoa have clean water and functional sewage because of a lot of time and work by Precon, but Precon didn't get paid for it. And that's
Mr.
exactly
Lewis,
what this, oh yes.
Can I ask you a question? Can you address the character, the nature of the work that was performed and why that shouldn't be important in our analysis under the substantial trivial test, and whether or not there is any case law, as Ms. Warren cites, to support the idea that we should care if the work is remedial or corrective or repair? Can you talk a little bit about that?
Sure. I think that those are sort of buzzwords. In a vacuum, they don't mean a lot. they sort of have a way of trivializing pre-con's work without looking at the substantiality and scale of the work. I don't think that those words by themselves are useful, but I think that a couple cases are illustrative, and they're from the 713 context that Ms. Warren has cited. And I think this is very important. The way that those terms are used in those cases, pre-con's work is absolutely doesn't fit those definitions. We've noted in our brief that the work wasn't accepted or put into service and then broke. So, excuse me for getting a little tied up here. The two cases are the Herpel case and the Viking Builders case. In the Viking Builders case, the work was accepted and then put into service and then later broke. Our case is much more like the Herpel case, where it wasn't accepted. Pre-con, like the Lenore and the Herpel case, the Herpel, they didn't intend to do this, but they ended up installing the work, leaving the site, coming back, taking it out, making adjustments, and then putting it back in. But the court in the Herpel case found that it was easy to see that that work extended the time to record the lien. And this is the important.
Okay, I'm sorry. I see why they're distinguishable when the Viking case deals with the AC that's working and then they come back for repair. I see your point there, but my question is, should we consider the nature of a repair ever in when we do the substantial trivial test, if that's the test that applies?
Sure. I think that I'll tell you specifically when. The distinction is some repair work and warranty work in particular. If the work has been accepted and put into service, which pre-cons was not, then since it has been accepted, the payment is actually due. And that's what should trigger the time to file suit. Payment was not due here until pre-con completed its work. It still had a substantial amount of work to do, so the final payment wasn't due. If only trivial work remains, then the payment's due. And I think that you can see that distinction is important in the Viking Builders and Herpel cases. I think that I've gone a little over my intended time, and I'll reserve the balance. Thank you.
Okay, Ms. Warren, you may proceed.
Good morning, Your Honors. May it please the court. I represent Applee Arch Insurance Company, and Arch is asking the court to uphold the summary judgment ruling entered by Judge Earp, finding that pre-con's claim against the bond furnished pursuant to 25505 is barred by the statute of limitations. What pre-con is asking the court to do is to disregard Judge Earp's ruling and instead reward it for doing deficient work and extending the time to file a claim under 25505. As this court has stated in previous holdings, that the trial court's entry of a summary judgment is clothed in a presumption of correctness if there is record evidence to support it. And here there is—
Ms. Warren, when you say deficient work, are you referring to the work that was done before the additional work that was done, according to Mr. Lewis, to make the tank operational? Are you referring to deficient work as far as the work in its totality that gets us to well into 2016?
So I guess in my mind, there's a demarcation. So there's the work that they completed in September or October of 2015. That's the original work. But that work was deficient in that the dome thickness was not what it was supposed to be per the plans and specifications. Pre-con then had to come back out and repair that and make it the required thickness after the engineer said, hey, they didn't do their work correctly. So when I talk about deficient work, I'm talking about this work that was performed, to correct their deficient work, I suppose.
Okay, well, that to me kind of begs the question then, if that work is deficient, then at that point, when it's measured and it's determined the thickness is not according to the specifications, doesn't that beg kind of a breach of contract claim as far as not performing as specified under the original contract?
Yes, Your Honor, but it doesn't transform Precon's work into being any less deficient.
But isn't your client then going to ask for Precon to make the contract whole or perform under the contract, which is what they were attempting to do by addressing and doing the additional work that resulted in getting the certificate for, I guess, the certificate that would make the tank operational at that point?
Well, in our client actually didn't make Precon go out there. It was our principal, Brandis. But yes, Brandis directed Precon to go out there to come up with a repair procedure and go out there and repair the work that it did not perform correctly in the beginning.
And before that work was performed, the tank never actually was filled and functioned. Is that correct?
I think there were some preliminary actions where it was chlorinated and it was beginning to be filled. It wasn't filled and used to its full capacity, but there were some preliminary tasks, associated with filling it.
Wasn't that just kind of a preliminary testing and making sure that it complied with all the specs pursuant to the contract?
Yes, Your Honor, but that was also necessary before they fill it up. That would, they would have to do that before they filled the tank all the way up too. That was just the necessary first step.
I think opposing counsel's argument is that we're bound by our prior precedent in Excel, which outlines a substantial trivial test as it relates to how we address this problem. Are we bound by Excel? And if not, why not?
Thank you, Your Honor. Yes, the court is bound by Excel, but I would argue that counsel for Precon is actually misinterpreting Excel. The key language from Excel, and I'm going to grab my case here so I can quote it for you completely. The key sentence is, when compared to the work done on the whole contract, punch list work is trivial and unsubstantial. So what the court in Excel is saying is that trivial or remedial work by its very nature is trivial, and that it is not counted in the computation of the statute of limitations period. It's not, as counsel would suggest, that some remedial work is, extends it and some doesn't. If it's remedial work, it doesn't count. It's not, the court doesn't have to, analyze this on an ad hoc basis for every type of punch list or remedial work. And I think our interpretation of this is in line with the other cases cited in Excel. It's in line with Viking. It's in line with, it's also in line with the subsequent case decided by this court, Delta Fire Sprinklers, which held that remedial work, even if it's, necessary to get the contract or the project to substantial completion, isn't counted for extending the time. And so
a situation then where, say, Precon had neglected to build the dome at all, would that be remedial work, or would that be completing the original scope of work under the contract?
Well, it depends on, I guess it would just depend on what other work they had to be done. Now,
well, let's just say they had to put a dome on it. Let's say in September, they issue their final pay application and they say, you know what, we're 100% done. And they pack up their bat and their ball and they go home. And the city engineer says, there's no dome on this thing. Come on back and put a dome on it. You're not done yet. According to how you're looking at Excel, is that remedial? Or is that just you didn't finish the job in the first place?
I think that might fall more into the you didn't finish the job in the first place, but we're clearly not in that camp.
What if you had a situation then where they put a wooden dome on top of it instead of a concrete dome? Same scenario, September, pack up everything, go home, we're done. City engineer says, no, the plans actually call for a concrete dome. Right. In that situation, are we remediating or are we completing the original scope of work?
You're remediating in that situation, Your Honor, because they built a dome, but it wasn't what it was supposed to be built. And I think the key here to realize,
so as long as any dome is built, no matter whether it's made of concrete or spaghetti, if you leave and say you're finished, you come back and you're repairing, and for purposes of the statute of limitations, we're looking at when you left the job.
Right. Yes, Your Honor. And yes. And I tell you why. Because You're asking for when the contractor is saying they are done with the work. And the contemporaneous records here show that pre-con, by all intents, considered itself done. If you look at the pay application, and I think this is actually a very important document to look at, this initial pay application they submitted in September of 2015. And for your honor's reference, that's record 545 to 546. If you go to the second page, there's a schedule of various tasks. I think there's maybe about 20, but I don't really know the exact number. But there's a column there that says % completed. And as of September 2015, pre-con signed, certified, notarized this pay application and submitted it to Brandis, the general contractor, saying it was 100% done with the work. But that's not all that's critical about this document. If you look down at the end of the schedule of values, there's a term, or there's an item for demobilizing. And, you know, pre-con got paid $30,000 to demobilize from the project. And that's what we're referring to when they left, right? And demobilizing isn't just this simple, you pick up your toolbox and you throw it in the back of the truck. I mean, you're moving all your heavy equipment off, you're moving all your forms and your scaffolding and all these things that are very burdensome to do. It's not just something you capriciously do. When you get off a project of this scope, it's a lot of undertaking. And in fact, it's $30,000 of undertaking. And so, you know, for them to sit here and say, oh, well, we submitted that. And I'm sure they would have gladly accepted payment at this point, right? If Brandis had, you know, stroked them a check for what they were asking, I'm sure they wouldn't have turned it away and said, oh, sorry, this is an erroneous pay application. We're going to 9 months later, we're going to submit a new one. I also think it's interesting is that if you compare the two pay applications, if you compare the work performed, the total work earned, on each of the pay applications, the amount didn't change. If this wasn't repair work, if this wasn't remedial work, and this is work they were expecting to get paid for, those amounts would be different. The only difference in these two pay applications is the amount they contend they were paid. And for your honor's reference, the second revised pay application is record 926 to 927. So it was this first pay application that Judge Earp relied on, coupled with the fact that there was record evidence in the engineering daily reports that said that pre-con had been demobilized off the project. So it wasn't an issue of, oh, we just submitted this and we knew we'd have to come back. It was, we submitted it and we got the heck out of Dodge and we took all our heavy equipment with us. And I think that is, those two things coupled together is what is really significant in this case. It's not just the pay application that said they were 100% done. Although as a couple of the cases cited in our briefs have said that, you know, pay applications, you know, the courts don't look favorably on using the pay applications for demanding payment and then using them as a shield for when you want to extend the date to file notices under the lien law or chapter 25505. I think they actually use the phrase, you can't have your cake and eat it too. And I think that's what pre-con is doing here. They're trying to have its cake and eat it too. They didn't do what they were supposed to do. They packed up their bags. They got all their equipment off the site. They asked for payment of all the money they contend they were owed. And then when they had to come back and repair, now they want to get some more time to file a claim against.
It just sounds like you're making an awesome closing argument to a jury.
Well, Your Honor, you know, I will tell you that, for instance, in Delta Fire Sprinklers, a case that was decided on summary judgment, I mean, the court there found that, hey, remedial work is not counted for purposes.
Why do we care about what Delta Fire says anyway? Does Delta Fire basically misclassify Excel as a lien case?
Does it misclassify the?
Yeah, it refers to Excel as a lien foreclosure case. Does it not?
Yeah, yes, Your Honor, it does. And actually,
that's a mistake, correct?
It is, but I actually think that actually underscores our argument that these cases are so interchangeably used that it makes really no difference. 25505 and chapter 713 are the same sides or the different sides of the same coin, right? A contractor could be working on a private
By
job.
my smile, I think you can tell I'm skeptical of that argument. What do we make, and I asked Mr. Lewis this, what do we make of that case that was in our district before it was our district that basically said, hey, these are two completely different things? I mean, the reason that we have 255 in the first place, at least arguably, is that you shouldn't be able to lien and foreclose on a public site. So 255 is created precisely because 713 doesn't cover it, correct?
Correct, but they both serve the same function, right? They both serve to make sure there's something out there to make sure contractors get subcontractors and contractors and subcontractors get paid. But they also enforce timely limits so that there's not an unlimited amount of time for liability to be out there. It cuts off the liability. And they all are measured from the same time. I mean, whether you're talking about Chapter 713 or 255.05, they all are measured from when the last day of work was. And I think, you know, in the construction industry, you know, a guy could be working on a public project one day and a private project the other. And I mean, whether that doesn't change that when his work is finished, whether he's the city of, you know, Cocoa is cutting the check, or if it's, you know, ABC Private Corp cutting the check. So, you know, and the fact that, you know, these cases are all interchangeably used, I think is, you know, very indicative of the fact that they're instructive of each other. And why not? Why wouldn't the courts want to borrow and use analogous situations to interpret things? I think that promotes continuity. It promotes consistency. You know, from a policy standpoint, if you were to adopt, you know, pre-con's position, you know, it'd be a free-for-all out there on public projects. Anytime there's the least bit of punch list work or remedial work, you know, the contractor will be thrust in this situation of uncertainty. Right now, contractors know, for the most part, hey, my punch list work doesn't cut it. And I need to make sure that I get my notices in or I file my suit when my last day of work was.
But counsel, doesn't that just depend upon what you consider substantial or trivial? If we call something a punch list, as Excel did, they put a footnote down and they said a punch list is a final list of small items. If it's a final list of small items, it's trivial. But if we put on a punch list, finishing that dome Judge Traver was talking about, wouldn't the substantial trivial test still say that that is substantial work? It's not, you know, it's not small, it's not fun. You need that. That's what I'm asking. Their test, their substantial trivial test, it doesn't get you into a place, does it, where you can just go back to replace 3 ballasts and extend the time period? You're still looking at the amount of work performed at the end toward the whole amount of work compared on the whole project.
Right. And I think what if it's remedial work, it's just outside the time regardless. And I think what's instructive is if you look at the line of cases that say, and I think Aronson's one of them, and I think it's Mishnal or that basically say if it's done not pursuant to the contract, it's incidental. Here, there was nothing in the contract that said that pre-con had to come back out 5 or 6 months later and thicken the dome, right? And otherwise, we'd be incentivizing contractors to do crappy work because then they can just, oh, well, I can come back out and fix it and then extend the time to file my bond claim or my lien claim. There, it says when they finish the work. And based on pre-con's contemporaneous project records, they certified that they were 100% complete. The engineer who was doing the daily reports noted in October of 2015 that they had demobilized. So it's not a situation where, you know, there was a clear demarcation point here. And I think to do otherwise would be rewarding them for, you know, not doing what they were supposed to do in the first place. And I think that's a greater detriment to the taxpayers than, you know. Sorry, I'm going through my notes. And and I'd also like to point out what is so instructive about Delta is that whether or not the remedial work that was performed was needed for the acceptance of the project, that isn't a consideration. So whether or not, Precon had to go out there and thicken the dome in order for the city of Cocoa to accept the project, the courts are pretty clear that that's not really a consideration. In Delta, they didn't even count that the inspection that was required by the owner, that was required by the contract. They didn't think that cut it. In Viking, I believe they didn't, the fact that the guy had to come back out there and do substantial work on the air conditioning, that didn't cut it. And the fact, and to Precon's point that because it wasn't put into service, that's some sort of demarcation point, that's not what the cases say. They say if it's remedial. They don't say if it's remedial, but before it's put into use or after it's put into use. It's if it's remedial, if it's corrective, if it's a punch list. All those mean that the work wasn't done properly the first time and they had to come out and fix it, which is what happened here. And I really want to go back to what we're looking at here in the standard is whether or not Judge Earp's summary judgment ruling is supported by evidence on the record. And at the time that he entered summary judgment, the undisputed facts were that Precon submitted a pay application in September of 2015 showing that it was 100% complete. That there was record evidence that on October of 2015, they had demobilized from the project and that they in fact had sought payment for such demobilization. And by the way, it's very expensive, as you can tell, to mobilize and demobilize from a project. That their work was performed between April and November of 2016, and that work was designated as repair work. They go to great lengths not to call it that, but it was a repair procedure. And last, that suit wasn't filed until April of 2017, which is greater than a year from the last day they were on the project, which was October 2015, if you give them the benefit of the doubt. Thus, there is sufficient record evidence and Judge Earp's order and subsequent final judgment are therefore entitled to a presumption of correctness. Thank you, Your Honors.
Thank you, Ms. Warren. Mr. Lewis, you have about a little over eight minutes.
Thank you, Your Honor. So I want to address a few things. Arch has characterized it as punch list work and said that can't extend the time to file suit. Judge Nardella is absolutely correct when she points out that this court in the Excel case has explained that when it says punch list, it means a final list of small items. So there was a punch list in this case. It was sent in July 6th, 2016, and it was a final list that contained small items. But the work that immediately preceded that in June 2016 and the several months before does constitute the performance of labor under the statute. Now, in this case, there was this unusual document, unhelpfully titled a preliminary punch list, which I think has caused some confusion. It was neither a final list, nor did it consist of small items. And you don't even have to take my word for it. The engineer of record, who's the person who created the document in December 2015, testified that there were multiple items on that list that Precon still had to do that it hadn't done yet. And that he did not consider, and he said he did not consider them punch list items at all. So that was not the punch list. Judge Nardella was correct that we need to compare the work that was performed to the scale of it to the scale of the work that was performed on the whole. There was some talk of the Rickards case and the Delta fire case. The Rickards case is the one where the court suggests the claimant was trying to have its cake and eat it too. In that case, the claimant literally did no work at all after the relevant date. And that was what was unacceptable about it. Precon's not trying to get away with anything here. Once it found out that its pay app was mistaken, it went out and it completed its work. The Delta fire case, Again, if you just say it's remedial work or just say it's punch list work, it's not helpful. You got to look at substantively what it actually is. And in that case, the work consisted of, quote, a final walkthrough and, quote, relatively minor tasks associated with it. So, of course, that's trivial. There's talk of the demobilization. There's also record evidence that work was done almost continuously during this time. If that's material, there's a disputed issue of fact. Now, again, with regard to the pay application was wrong. It's pretty unanimous. And I don't really hear Arch argue otherwise. They just sort of argue, here's the pay app and pre-con signed it. Where if you really look at the facts and the testimony and the evidence, the pay application was wrong. With regard to, briefly, the 713 cases, look, there are many instances where 713 and 255.05 use the exact same language, and there's many instances where the two statutes do not. In this case, in this instance, for the statute of limitations, they don't. The legislature knew how to use the terms final furnishing if it wanted to, but it chose not to. I think it's more fair to say that 713 cases are helpful in the absence of other authority, but the circuit court in this case had other authority. It had the Excel case, which is right on point. And then I think my clock has disappeared. Oh, there it is. Sorry, I had a Zoom issue. Oh, excuse me.
I'm sorry. I'm going to have to ask. My screen froze up. I don't know if anybody else's screen froze up when you were about, I don't know,
I think I know when it froze up.
Okay. So I'll give you some time. Go ahead.
Okay. I'll, for your benefit, I'll repeat what I was saying. I was just briefly addressing chapter 713 and 255.05. There's many places in the two statutes where the statutes use the exact same language, and there's many instances in the two statutes where they do not. In this instance, they do not. The legislature knew how to use the same words if it wanted to, but it chose not to. I think it's more fair to say that 713 cases are helpful if there's an absence of authority in the 255.05 realm, but in this case, the circuit court had other authority, and it's your Excel case. And I just want to ask that you consider this. To the extent you're interested in any of these other tests, other than the substantial trivial test in your Excel case, which asks us to determine just whether the work is substantial or trivial, I submit that your test is so much better. The relevant work that pre-con performed took several months to complete, and pre-con payment wasn't due to pre-con until that work was complete because it still had a lot to do. So it was several months. It's not hard to imagine a case in the future where a claimant's work takes just a couple months longer and therefore lasts over a year. If that type of work doesn't count, then it's entirely possible that a claimant in the future would be forced to sue for non-payment before the payment is even due. Think about that. That's an absurdity, and we avoid construing statutes in a way that creates an absurd result. The claimant could be out there doing work. Everybody's getting along. They're doing the right thing, and the payment's not even due yet because the work is ongoing. And they'd have to sue just because some document was created that says the word punch list on it, or just because they're working on components of work that they touched before. But the substantial trivial test fixes that. Trivial work could never take over a year to complete, but substantial work could. So that's why substantial work should extend the time to file suit. And this really isn't inconsistent with the existing case law in the 255 or 713 context. And I've alluded to some of them, but in Excel, it was small items. Those were trivial. They didn't extend the time. In Delta Fire, it was a final walkthrough. In Rickards, there was literally no work. In a different case, I don't have the name of it, but I think Judge Nardella referenced it. There was just 3 light fixtures that were adjusted. all this to say that we cannot have a statute that was designed to protect subcontractors that do the right thing, interpreted in a way that could literally force them to sue before the payment is due to them. There was this suggestion that Precon got paid for demobilizing. It asked to be paid for demobilizing in the pay application that is unanimously considered wrong. My understanding is that it did not get paid for that work. That's why we're here. With the minute or so I have left, I'll address the 4-factor test that Ms. Warren has advocated for. I'll remind you of the Herpel case where the claimant did not intend, once it had installed its work, it did not intend to go home and then come back and then make adjustments and then put it back in, but that's what it did, and it extended the time. In its brief, Arch only addresses 2 of the 4 factors. They don't address whether the work was done in good faith and within a reasonable time. We say Precon satisfies all 4. Arch says, no, you only satisfy 2 of them. The answers to the 4 factors are exactly the same here as they are in the Herpel case. They're so similar. So I submit that even if Arch is right, Herpel suggests that those 2 factors alone are enough to extend the time. I'll conclude. Because the trial court failed to employ the substantial trivial test and instead relied on a mistaken pay application, despite an abundance of contrary evidence as to the timing and substantiality of Precon's work. And since Precon's work constitutes the performance of labor under any other circumstance, we ask that you reverse the summary and final judgments in favor of Arch, and on remand require that summary judgment be granted in favor of Precon on the statute of limitations issue. Thank you.
Thank you, counsel, for your arguments, and